General Sibiya has been summoned to appear before Parliament's ad hoc committee on the 10th of September. Now, the ad hoc committee is investigating allegations that were made by KwaZulu-Natal top cop Nhlanhla Mkwanazi about police interference and corruption in law enforcement. In fact, the issue of the 121 dockets that are also with the Madlanga Commission has come up in the Pretoria High Court. That's where Deputy National Commissioner Lieutenant General Sibiya is challenging his suspension. In fact, through his lawyers, Sibiya refutes allegations that he interfered with the work of the political killings task team. We've roped in Professor Dirk Kotzé, Professor of Political Science at the University of South Africa. Prof, a very good afternoon to you, and thank you so much for joining us this afternoon. So just having listened to, of course, that court case earlier on and other issues around General Sibiya, now suspended General Sibiya is fighting his suspension in court, as we've seen. He's also now being summoned to appear before the ad hoc committee. What do you make of these latest developments?
Yes, good afternoon. First of all, his appearance in Parliament is something which is a must. He is one of the key players in this situation, and that he therefore, after General Mkwanazi, will possibly be, as well as the Minister Mkunu, are the three main players in this situation. So they all three have to be in Parliament and appear before this committee. Otherwise, they won't be able to do their work. So there is not something untoward or out of unprocedural, or that it is actually has some impact on the court case that is at the moment happening. He is one of the key persons that must provide the ad hoc committee with the very necessary information that they can use as the point of departure. And I think that will be in the end also a lot about what the conclusions will be about what he can say, as well as General Mkwanazi again. So that is, I think, is highly expected that he should be in Parliament, and that they should take their time in order to investigate what he is saying, and also almost interrogate him, but give him the opportunity to present the information to the committee. With respect to what we see in the court case, I think this is something different. It's more about his working relationship within the South African Police Force and his current status there, especially in relation to the National Commissioner.
Now, there are concerns, growing concerns, in fact, especially from the MK party, about just the slow pace of the ad hoc committee, probing General Mkwanazi's allegations. What does this signal for you, just about political will, in terms of dealing with corruption and police interference, especially when you consider there are so many, structures that have been set up to look into this matter?
Yes, I think in the case of the MK party, they have obviously played a role of opposition to a large extent, and although they are part of this, the ad hoc committee, the parliamentary committee, and I think at the same time they are most possibly will be able to, or will try to use it for their own benefit and their own purposes also. I think what we are seeing in both cases, both the Parliamentary Committee as well as the Commission of Inquiry, is that it takes quite some time to get it going. And that's not unique. It's not because of, that there's inefficiency or so. It is on the side of the Commission. Well, there's already some form of consequence management with respect to some top persons in the Department of Justice that happened. But I think in Parliament it was the same. They have not so long ago only been able to finalize their terms of reference. But I think for them, one of the main responsibilities is to have a very concentrated, focused sessions with the three main personalities in that. And that is the Minister and the National Commissioner, and the Provincial Commissioner Mkwanazi, and actually the fourth one is the Deputy National Commissioner Sibiya, that all of them can present their information and their cases to the Commission in order to give the necessary background. all the rest will be important additional information, but in the first instance, we must understand what they know and where they stand and what happened. The time frame of the Parliamentary Committee is very short. It's until the end of October, so they have basically 2 months or less than 2 months left. So it is an indication that their terms of reference is much less than that of the Commissioner of Inquiry, and therefore it is not expected that they must do exactly the same as the Commission.
Yeah. In terms of the issue of the 121 dockets, now there's obviously a lot of concern given just the number of stakeholders we understand have access to these dockets. These are really at the center of the controversy. Now, in fact, Sibiya's legal team distancing him from commenting, in fact, on the fate of these dockets it could be a legal strategy. But of concern, of course, is that the Nhlanhla Commission is now linked to these dockets. I mean, do you see any form of duplication of processes here? And what does it also mean from a public trust perspective in just the state's ability to tackle political killings or any other high-profile crimes and to protect the integrity of law enforcement?
Yes, as far as I understand, the 121 dockets have been handed over to the Commission now. So it's now in order to actually create a neutral space for it. And it is not being, there should therefore not be any accusation that it has been abused or mismanaged or any of those matters. So, but at the same time, it means that there's no progress, active progress possible during the time of the Commission. I think what the Commission, what this issue is in a sense indicating is that there's a lack of trust between the main personalities, and especially the National Commissioner, General Masemola, and the Deputy National Commissioner, Sibiya, and then at the same time involving General Mkwanazi. So I think this is a way of resolving it for the moment. And in order to where it should be and whether it should be activated again, whether the investigation should start again on these matters. But for me, I think it's not so much about the Commission or the Parliamentary Committee to make any conclusions about these dockets, but rather to preserve what they have there, that it's not being manipulated or in any way being abused in this process, because that is indeed a high possibility. That it is such explosive information that's most possibly included in this, that there are many parties that have a really direct interest in order to get either rid of these dockets or to manipulate them in some other way. The question about the duplication between the two processes has always been there since the creation of the two.
Absolutely.
And I think what is therefore, they will have to have a discussion, maybe even informally, of how they're going to make that distinction, that they don't, for example, reach conclusions which are contradictory. That is the one thing that they will have to avoid at all costs, that the parliamentary process reach one conclusion and that the Commissioner of Inquiry ultimately reach a different conclusion or something completely in contradiction with it.
Yeah.
So I think there will have to be different focus areas, and that because the Parliamentary Committee has less investigative powers than the Commissioner of Inquiry, the focus of their attention, therefore, will have to be less, and the conclusions will have less of judicial nature than the Commissioner of Inquiry.
Prof, thank you so much for your analysis. Really do appreciate it. That is Professor Dirk Kotzé, Political Sciences at the University of South Africa.